So you're still through to the Asasa Breakfast Show here on 99.5 in Accra and our sister stations in Cape Coast, Kumasi and Tamale. 7:55 the time on the clock. And now to the first item in What's Going On. What's going on? Well, all the news you'll know from looking anywhere in the prints or on online has been about that court decision yesterday in the United States in the matter of Kennedy Agyapong, the former member for Asin Central, and the investigative journalist Aremeyaw, to do with a matter of defamation. The former MP for Asin Central, reputed to have named Mr. Anas certain names, let's put it that way, on national TV here in Ghana. A matter that ended up in the law courts in the United States, and back in March, a judgment given by a jury determining that Kennedy Agyapong had fallen foul of the law, had defamed the journalist, and awarding damages of $18 million against him. The counsel for Kennedy Agyapong having applied to the court for it to be taken into review, and yesterday the news breaking that although Mr. Agyapong has been found, the charges have not changed against Mr. Agyapong, or the findings against him have not changed. That judgment has been lowered to $500. Joining us now on Zoom to discuss the matter of the judgment, lawyer Eric Okyere, a member of the Kennedy Agyapong legal team, who joins us live and direct from New York. And we say good morning to you, Mr. Okyere.
Good morning, and how are you doing?
We're very well, and lovely to see you again. You were lately here in the studio, of course, on the Asasa Breakfast Show. Nice to see you in your own domain. And some welcome news from your point of view, from the point of view of the quantum of the reduction in judgment. Now, the remitter mechanism to which you resorted to ask the court to review its judgment, a well-known resort within U.S. legal practice. Were you surprised by the quantum of the reduction of the fine on Mr. Agyapong?
You know, I have to correct some facts on the record first before I answer your question. First of all, there was no judgment of $18 million entered by the court on March 18th. This was a very bad PR done by Anas without any legal basis. The reason is that the jury returned a verdict of $18 million, but the court did not enter judgment because it was clear that there was an error on the face of the record. So it was at that time that the jury were dismissed, and the judge asked the lawyers to put our argument on motion. So the argument was still pending before that very court. There was no judgment entered at all. Now, there was no legal basis for Anas to be awarded $18 million. The reason being that the jury returned a questionnaire during the course of deliberation on punitive damage, getting clarification from the judge and stating on record that they awarded $5 million for Anas for compensatory damage, $5 million for actual damage, and $8 million for punitive damage. Under New Jersey law, if an individual does not prove actual damage, they do not qualify for punitive damages. So in this particular case, Anas could not prove any actual damage against him for the alleged statement made by Honorable Kennedy Agyapong in New Jersey, which resulted in this particular lawsuit. Now, if he is not liable for actual damage, which is $5 million that the jury awarded, that $5 million is out of the record. Once you don't qualify for actual damages, you do not qualify for punitive damage. So the 8 million is also out of the question. It was only left with the nominal damage, which the jury awarded $5 million. Under New Jersey law, the maximum you can award for nominal damage is $500. So we knew we had won the case from, especially on the verdict side, from the very day that the jury were dismissed. So clearly on the record, Anas is only entitled to $500, not the $18 million that was awarded by the jury. And that is what the judge molded the award and entered judgment yesterday.
So you say that there was clearly an error on the face of the judgment, which put you on good ground to bring the plea under the remitter to the Essex County Court. Was that purely to do with the procedural improprieties they're described as in one other source in the case made by Anas, or what were the other errors on the face of the judgment from your point of view?
So the error on the judgment is that Anas did not provide any evidence to support actual damages. So during trial, as part of the mini trial, the judge made a ruling that Anas does not qualify for actual damages because there was no any evidence adduced. In fact, in his pleadings or his summons, he did not allege any actual damages. So that is one of the major errors on the face of the record, where the jury went outside of their mandate to consider actual damages, even though there was no proof. And of course, once there is no actual damages, you don't qualify for any punitive damages. So Anas was limited to only nominal damages according to the lawsuit that he filed.
One would have said on the face of the matters that were under discussion and the allegations made by Kennedy Agyapong in the public glare that if nothing else, Anas was perfectly within his stead to suggest that he had suffered some kind of reputational damage. So the procedural way in which he presented his case may not have stood up to scrutiny from the point of view of legal expertise. But do you accept that, in his words, most importantly, that is in Anas's words, that avenues of redemption still accrue to him? The judge still held that Kennedy Agyapong had defamed him, and in his reasoning, it was simply that the award against the former MP was excessive. So actually, the $5 million nominal damages, whether reduced to $500 or not, the substance of the case stands, that Kennedy Agyapong did indeed defame Aremeyaw Anas.
Well, there are legal loopholes in that argument. The question of whether the jury found that the words used by Honorable Kennedy Agyapong was defamatory is settled, because if you call someone a criminal, you need to have a criminal conviction in order to prove that the person is a criminal. So in this particular case, there were some words used by Honorable Kennedy Agyapong which could not be proven as truth during the defamation trial. And that part, Anas, is right to say that the jury found that some of his words used against him in a TV appearance was defamatory. But to talk about the fact that the judge reduced the amount, it's as if the judge is doing a favor to Honorable Kennedy Agyapong. That is not the case. The judge didn't do any favor. It is clearly within the law of New Jersey on defamation that you must prove actual damages. Yes, your reputation may have been ruined, and that is why you have a court decision that says that you have been defamed, and you have a paltry $500 as compensation for that. But you could not prove that based on the damage to your reputation, you have lost financially substantial. That was not proven, and that is why he doesn't qualify for anything less than $500.
So we also have a member of the Aremeyaw legal team on the phone to talk to us. Evans Adika is a member of the team, and we say good morning to you, sir.
Good morning, and good morning to your cherished listeners.
Thank you very much for joining us on the Asasa Breakfast Show. I hope, Mr. Adika, you'll have heard at least some of what Eric Okyere had to say there.
Yes, I heard bits and pieces of it. I heard the part where he said my client had conducted very bad PR. I strongly disagree with that.
We'll get round to, if you like, your detailed.
Okay. So you can fire away. I'm all ears.
Sure. So there is the matter of the quantum of the damages awarded you by the jury back in March. He suggests that you failed to present any actual evidence of harm or damage having been done to his reputation.
The document that is out in the public domain simply says that it was granted. These are issues that are determinable by resort to the record and the transcripts of what actually transpired at trial. And since we have every intention of pursuing an appeal vigorously, we're not going to reach into those issues. Mr. Okyere says that my client didn't present proof of actual damages. We respectfully disagree, and that actual damages is a term of art. I'm not going to debate him on radio as to what elements of proof a plaintiff needs to proffer in order to meet that burden. Anas did get on the stand and did testify to the effect of this defamation on his reputation. We believe that is evidence enough under the legal standards that are applicable. And so we will be looking at the transcripts. We respect the court's decision. It's nothing that we haven't encountered before in practice. We will look at the transcript and we will determine whether or not the judge abused his discretion in reducing the jury's verdict.
So, as you say, all that is out in the public domain is that formal announcement of the reduction in the assessment of damages due to Aremeyaw to $500. But yes, as you say, as a lawyer of some expertise and experience in the matter, you will have your own opinion from the way proceedings ran in the original lawsuit as to exactly why there has been that reduction of the amount.
I think you were breaking up, so I didn't quite hear your full question.
I was saying, even though it might not have been stated in the published verdict by the judge, from your own experience and your knowledge of this field, you will have some ideas why perhaps there has been this reduction in the quantum of the amount.
Typically the judge would reduce it if it's excessive, which means that there might be some issues as the evidence, the weight of the evidence, which is why I say the best way to go about this is to resort to the transcript and look at what exactly transpired, because that's the reason why the transcript exists, is to look at what exactly transpired and to determine whether or not we entered evidence of actual damages or not. That's only going to be determinable on the transcript. That's my point.
Well, it sounds like a curious course of action to want to pursue, if you don't mind my saying, Mr. Adika.
I'm sorry, you're breaking up.
It sounds like a curious course of action to want to pursue when the statement issued by Aremeyaw yesterday seemed to suggest that the quantum of money was nothing to do with his interest in the case. In his words, he said he was happy that not a single allegation was proven against me in court when Kennedy Agyapong was given full opportunity to substantiate. And it is important to state, as I previously did, that this fight has not been about the money, but rather a fight for truth and justice. In that case, why would you want to appeal the quantum?
Oh, I mean, it's a fight for justice. But if you remember, the question you asked me was in relation to what my learned friend, Mr. Okyere, said. And my response to that is that we will look at the transcript to determine whether or not what he's saying is right, and if we have grounds to appeal. So I haven't said for certain that we are going to appeal. I just said we're going to review the transcripts, because typically when a judge makes such a decision, it's based on his determination that there was some evidence that's missing. So that's if I state what I state, that's the reason why I say it. That doesn't take away from the statement that was released yesterday. We went to court to clear my client's name. The damages were more of a deterrent, to deter future conduct. So, what I say is not in conflict with the statement that was released yesterday.
So would your primary objection, if you do indeed decide to go to appeal against the decision to award your client $500 only, would that be that that serves as insufficient deterrent in future to people who may want to engage in the same kind of commentary as Kennedy Agyapong did?
I'm sorry, but it's just really like, you go in and out, so it's really difficult to hear your full submission. Can you repeat that?
My question is whether you think the $500 judgment will be sufficient deterrent in future to people who may want to engage in the same kind of commentary as Kennedy Agyapong did.
Well, it may, and it may not, in the sense that we've all seen that he's been very measured since this first came out on March 18th in his pronouncements. We applaud that. We're very happy about that. As far as whether or not it will be deterrent enough, that left to be that's still to be seen.
So if you've seen a modification in his behavior, why would you want to appeal? Does that not suggest that the money is a prime motivating factor for your client?
I'm sorry, I didn't quite hear that again.
If you are satisfied with Kennedy Agyapong's conduct since the judgment in March, why would you want to appeal? Does that not suggest that money is the motivation for your appeal?
As lawyers, we have a duty to our client, and which is to make sure that if there are any actionable, if there's any cause of action that's actionable, or there are any legal steps that need to be taken, we apprise our client of that and let that be his decision. So, we are just going to order the transcripts, and we're going to look at the transcript, and then we're going to have a meeting sometime later on this week. The whole legal team is going to get together, and we'll make a decision one way or another. I'm just answering your questions at this point.
So, Eric Okyere, you've heard there Evans Adika, the member of Aremeyaw legal team, suggesting that it's not over. Kennedy Agyapong may have been granted a Hail Mary pass by the courts, having made that Hail Mary plea under the remitter to the Essex County Court judge. But in effect, what you have is the possibility of further legal action. Kennedy Agyapong's statement suggesting yesterday that the judgment was a resounding legal vindication. Is this not what you would describe as a Pyrrhic victory on both sides?
I actually disagree with Counsel Adika's rendition of events that he just stated on record. It is Anas and his legal team who mounted a PR stunt when there was no judgment entered by the court. They just started jubilating when the dust had not settled. And now after the dust was settled, they found out that they were only entitled to $500. Now, they came for money. They didn't get the money. That is where the pain is. Honorable Kennedy Agyapong stated that even if he used those words, his only liability under New Jersey law was $500. And this was what was offered to them even before the trial started, that even if my words were defamatory, you are only entitled to $500. So they can go ahead and study the transcript all they want. We are here. We are ready. They can come back to court and we will beat them and beat them and beat them. That is what it is. They have no legal basis to get any substantial money from Honorable Kennedy Agyapong, and we stand by the ruling of the judge. And by the way, it was a molding of the jury verdict. It was not a remitted. So the judge molded the jury's erroneous verdict to conform with the law. That is what happened here.
So what you're suggesting is indeed that this award, as in the words of the statement of Kennedy Agyapong, the award by the judge is merely symbolic. Indeed, a clip was circulating yesterday of the Kennedy Agyapong and members of his, let's say, his close associates and his campaign team rejoicing at this decision. Your suggestion that the judgment is meaningless could be seen by some almost to be regarding the whole legal process in the United States with some contempt.
No, nobody is saying the judgment is meaningless. We are saying that his only entitlement, as far as monetary compensation is concerned, is $500. And that is a jubilation, because if a jury in an error awards an $18 million to a party, and the law corrects it to the rightful amount of $500, that is a win, and that is something to celebrate about.
It indeed might be, but the substantial charges stand that Mr. Agyapong defamed Aremeyaw and that the court has not found against that judgment. In what kind of light do you think that presents Kennedy Agyapong, particularly as a media owner in his own right?
I already put it on record that if you call somebody a thief and you are unable to show a conviction record, that word alone is defamation per se under New Jersey law. There were words that was used by Honorable Kennedy Agyapong that has no documentation to back up those words. I'm not repeating it here, but that was what is considered as defamation under New Jersey law. In other jurisdictions, probably it might not even be considered as defamation when there are other circumstances to prove such a case. But here under New Jersey law, to call somebody a criminal and other words, you just have to have the documentation to prove that your statements are true. That is where it ends. But it does not stop Honorable Kennedy Agyapong for standing for the truth for Ghanaians, for defending the truth in Ghana, and he will continue his effort to make sure that the right things are done. So if somebody is using the wrongful procedure to put other people in unnecessary legal predicaments, like what happened to GFA chairman, Kwesi Nyantakyi, there was no proof, no basis. If Anas had evidence against him, he should go to Ghana court and provide those evidence.
Here, Mr. Adika, you're venturing into matters other than the particular legal matter that we're trying to discuss in relation to your client. So I take your point. Would you please give me a minute, because I wanted to put that to Evans Adika. Mr. Adika, you'll have heard there the submission by... Hello, you will have heard.
Yes.
You will have heard. I hope Eric Okyere say, one, that you presented no documentary of evidence in court that Kennedy Agyapong defamed your client, Anas, and two, that in effect the judgment carries no weight. your response to that, and also the particular charge that you engaged in a PR campaign against the jury interim decision about $18 million.
Hello?
Hello, Evans Adika. I hope you could hear me.
Yeah, I can hear you now, yeah.
Right. So I was saying your response, please, to Eric Okyere statement, one, that you produced no evidence in court to prove that Kennedy Agyapong defamed your client, and secondly, that in effect you engaged in a PR campaign around $18 million decided by the jury, because that was your prime objective in bringing the suit.
Okay, so to respond to the first claim, I didn't specifically hear him saying that we didn't prove our claim of defamation in court. If his position is that we did not prove actual damages, once again, I'm going to respectfully state that until we get the transcripts, because the evidence adduced was testimonial in nature. So the only answer to this question of whether or not Anas got on the stand and testified to the harm that this reputational damage did to him, then we will only go back and forth where I would say it exists and he would say it doesn't exist, which would just waste the time of all your listeners. Now, to the second question about the PR campaign, I implore Mr. Okyere to go and find any evidence where we have stated that we have a judgment. All we did was report things as they happened in the court. All we reported was that a New Jersey jury had awarded my client 18 million United States dollars subject to post-trial motions. I was on Newsfile the Saturday after that, where I explained that and I said, look, all we have is the jury verdict. It is their prerogative to file a host of post-trial motions that are available to them, and let the procedure take its course, which it has taken its course, and we're going to respond accordingly. But no one set out to misinform the public that we have judgment. I don't recall ever saying that, and I'm the one who has spoken for the legal team throughout all of this, and I have never said we have judgment. I said we have a jury verdict that we are aggressively looking to reduce to judgment, followed by execution. This whole talk about we went for money and we went for money. At the end of the day, I just said that the money, we believe, is of deterrent effect. So, yeah, we did go for money. And if it's available and based on some of the pronouncements that have been made subsequent to what happened yesterday, we would look at the transcripts, and if we have a plausible case for an appeal, we would consider it as a team and talk to our client and make that determination. That's all, that's all I have to say.
So, Mr. Adika, your client said in his statement issued yesterday that he's going to continue his fight against corruption, and in doing that, to continue to name, shame, and jail. It seems we've reached the rather curious position where the two sides legally have fought each other to a standstill. In the interests of pursuing the fight for truth and justice, would your client not be best advised to return the matter back to the primary area where these matters need to be judged, which is in Ghana, and perhaps the courts in Ghana rather than the United States?
I'm sorry, but you're breaking up pretty badly, and I think the import of your question is along the lines of bringing a case back to Ghana.
Yes.
I think that's beyond this conversation. Like I said, we will be meeting sometime this week, and we will look at our options, and we will begin to look at the record and the transcript, and and make a sound legal decision as to the way forward.
So, Evans Okyere, you heard there Evans Selassie Adika saying very much that the jury's out, to use a bad pun, but that it all depends on essentially the detail of the judge's decision. Do you not think that you have fought each other to a standstill, and there is nothing to be gained by either side in continuing to pursue this matter through the law courts, either in the US or Ghana?
I must correct Mr. Adika again. There is a ruling in Ghana, both from the High Court and the Court of Appeal, where Honorable Kennedy Agyapong won this on the same defamation case against Anas. Anas then comes to the United States and used one TV appearance by Kennedy Agyapong and filed this instant lawsuit. Well, it got him $500. If that is what he was looking for, he got it. But there is actually a draw, if we call it that way, because there is a ruling by the judicial system in Ghana saying that Honorable Kennedy Agyapong had not defamed Anas. And this went on to the appeal courts. So it is a draw, if anything at all. But it's a draw where it has caused somebody deep in their pocket than another person.
So for you, the fact that you may have scored a win and put Anas Aremeyaw and his legal team to some discomfort financially, that's the prime motivation?
It is not the prime motivation. As I said, that Honorable Kennedy Agyapong always stand for the truth and fight for those who are voiceless. And he would not stop fighting for the truth in Ghana and elsewhere that he finds himself. That is who he is, and he would continue on fighting. And that is why I cited only one person just as an example, that we destroyed somebody's career whilst nobody was speaking the truth for the person. And that is totally wrong with the way Anas conducts his investigation. That has to be put on record. Kwesi Nyantakyi shouldn't have gone through what he went through at all.
So, Evans Adika, you'll have heard there that, in effect, I hope you're still on the line to us, that,
I am,
that Eric Okyere thinks that, in effect, this is a victory for his client because your client, Anas Aremeyaw Anas, has engaged in some, shall we say, unethical behavior as a journalist, not only in relation to his client, but to other people.
I'm sorry. I couldn't hear any of what you just said.
The response by Eric Okyere is to the effect that this case has only come about because of unethical conduct by your client in his pursuit of journalism.
I take strong exception to that. Mr. Okyere is a lawyer. I have great respect for him. I actually met him in New York, in New Jersey. But I think we should be circumspect in some of these pronouncements. Because, yes, I do empathize with Kwesi Nyantakyi and what he went through. But Anas's job and the way he goes about his work is controlled by law, right? And if anyone feels like the way he goes about his work violates the law, let's go to court and let's hash it out for the good of the country. But to just sit on radio and say it is unethical, that's defamation in itself if you can't prove it. If we were to go to court and the court upheld the modus operandi that my client uses, Mr. Okyere has effectively sat on this radio station and defamed my client by claiming he engages in unethical conduct. He's a lawyer like I am. If anyone takes strong exception to the modus operandi, the Supreme Court is open. Our courts are open. Let's go and get an interpretation of the law. But I say this just to keep the door open. But Ibrahim Sani Dara, I recommend him greatly. He took the same issue to court and lost. If circumstances have changed and someone feels like they can articulate the position that he sought to articulate, they should pursue it. But let's not sit because look, as lawyers, we are to educate lay people and the public. So for Mr. Okyere to sit on radio when he has not himself as a lawyer or he hasn't gone to court to test the legality of it, and just say it just because he's been given the platform. I mean, Mr. Okyere, you shouldn't be engaging in that. I know him, and I know he's a man of integrity, and he watches what he says. So I'm going to say he said that out of excitement, and I'm not going to.
Mr. Adika, listen to the words I used during my submission. Do not take it from a summary from the host. Listen to the voice.
No problem. Acknowledge.
So forgive me, Mr. Otradaku, if I overinterpreted your comments there, but that to me seemed the substance of what you were saying.
We're building a country. These are legal issues. When they come up, let's let the courts, if anyone feels like they have a strong position, let's advocate, in a civil manner. This is not a fight. I have always said, we're not fighting. This is a case. And we fight it out in court, and let the sound legal position win for posterity. That's what we're about.
So, Mr. Otradaku, I finally wanted to ask you, given where we are with the standoff between the two sides, and if, in effect, both sides seeming both to have lost and to have won, at least to the layman, from the layman's point of view, nobody wins or no side wins, least of all journalism. How do you think the matter should be pursued to ensure that indeed there is a deterrent effect, and that public figures mind how they comment on matters of journalism and indeed investigations into their own conduct in the public gaze?
Well, my submission is very simple. That Honorable Kennedy Agyapong stands for the truth and fights for the voiceless. So if the journalists who use the medium they have to harm other people's reputation, Honorable Kennedy Agyapong will speak up for those people who don't have voice to speak. That will not change his nature, and it will not change the way he does his things. We also employ all the journalists to make sure that they give those they are investigating a fair chance to know that they are being investigated. To know that they are being trapped or entrapped. That has to come clear. And Honorable Agyapong will fight for anyone who is subject to any type of journalistic conduct that he deemed not to be appropriate. That is going to be something that he has taken up the fight, and he is not going to stop that fight.
Evans Adika, I think the line may have gone to Mr. Adika. And so on that note, perhaps if I can ask you finally, Eric Okyere, your client is on record, for example, in 2012 for having declared a state of war on live national radio. You heard Evans Adika say that he has been pleased in the moderation of tone and the commentary that has emerged from Kennedy Agyapong since the finding by the New Jersey court. Do you expect this to continue? And if it doesn't, what do you think other people who are offended by Mr. Agyapong's behavior should do? Take recourse to the law if all they're going to get is a $500 judgment?
You see, it is only a fool who does not change with time. Honorable Kennedy Agyapong had been a firebrand politician for a long time, has served his community for a long time, and may have stepped on a few toes, if not many. However, if you compare Honorable Kennedy Agyapong of 2012 to Honorable Kennedy Agyapong today, you will see a big difference. He has matured, he has reformed, and he is a presidential candidate, if I should use that word. His utterances are totally different from when he was a young politician trying to build a brand for himself. He is going to continue to conduct himself as a presidential candidate, and he is going to continue the fight also for those who have no voice. We believe that people in Ghana have seen the difference between Kennedy in the past and Kennedy at this present.
So Eric Okyere, attorney at law, speaking to us from the state of New York there, a member of the legal team for Kennedy Agyapong, the former member for Asin Central. Thank you for joining us on the Asasa Breakfast Show. And also thanks to Evans Adika, who joined us also from the United States, a member of the legal team for Aremeyaw. Pyrrhic victory, fight to a standstill, fight to the death. Your opinion as good as mine.
Thank you for watching. like, comment, share, and subscribe.